Hello, I'm Angela Princeville from AP Lawyers, and thank you for joining me on this segment of Ask AP. The question I am answering today is, are foreign assets included to be divided? So, well, it depends. I feel like I always say that, but that's the reality, right? The facts of every case sort of make things different. Short answer is yes, there's nothing special about foreign assets that takes them out of the equalization process. Now, obviously, I know a lot of people own foreign assets that are inherited property, for example, then that would be dealt with when you're doing your equalization, as it would be excluded if that's the case. Or if it was something that was owned on the date of marriage, then that would be dealt with that way. But you don't just remove, excluded property by virtue of the fact that it's not in Canada. So it is foreign property, is an asset, and it is subject to division. Now, I hesitated a little bit starting off because the question didn't really make it clear if we were talking about um, property being divided between common law spouses or if we're talking in the context of equalization. So if you're in a common law scenario, the rules are sort of different. But the difference here is not so much that it's a foreign asset, it's whether you can establish an unjust enrichment claim against that foreign asset. So on a high level, generally for a common law spouse to be able to share in a property that's not in their name, they would have to bring a trust claim. And essentially, what you're trying to show with that trust claim is that you will be unjustly enriched if the other party is allowed to keep that property merely by virtue of the fact that they are entitled to it and you're not. Now, there's tests that you have to meet, factors that you have to establish for your case to be successful. So, if we're dealing with a foreign property, obviously, I'm guessing I shouldn't even say obviously that there might not be sort of that connection. It might be harder to show a connection, show unjust enrichment, show your contributions if it's not an asset that you had access to. Now, again, depending on the facts of the case, it might be a foreign asset that the parties could have shared throughout the common law relationship. So in that case, it is fair game and can be subject to part of the property division conversation among the common law spouses. But for equalization, it's a very straightforward process, subject to deductions and exclusions that you're entitled to, or even in some cases, if you're trying to make a claim for an unequal division based on the value of some property for whatever reason, those are all options that are available to you. Of course, once you get independent legal advice on that, but simply put, the fact that a property is not in Canada doesn't mean that it's excluded from the equalization process. It is included. And so that's my answer for you. So the answer is yes, your foreign asset must be included on your financial statement and it forms part of the net family property calculations. So until next time, it's bye for now.